Well, welcome to the next panel. I'm Greg Dotson. I'm a professor here at the University of Oregon School of Law, and thank you for joining our discussion about Sackett versus EPA. Before we get started, I just wanted to take a moment to recognize that we've been joined by Representative Bonamici here from the House of Representatives. She's on the Environment Subcommittee of the Science Committee, which puts her right in the middle of so many environmental issues, and her work on the Select Committee on the climate crisis in the last Congress really laid the groundwork for the Inflation Reduction Act. So thank you so much for joining us. So I'm going to be moderating the conversation between two experts that'll help us understand the legal effects of the Sackett decision as well as the practical on-the-ground impacts. Joining me is Professor Adell Amos. She is the Clayton R. Hess Professor of Law here at Oregon and a nationally recognized expert on water law. Her research emphasizes the jurisdictional governance structures that are deployed for water resources management. Her teaching and scholarship have been recognized by the UO Fund for Faculty Excellence and the Hollis Teaching Awards. Professor Amos first joined the faculty in 2005 after practicing law with the U.S. Department of Interior. In 2008, she returned to Washington, D.C. to serve in the Obama administration as the Deputy Solicitor for Land and Water Resources at the U.S. Department of Interior. She has returned to the U of O School of Law in 2011. She holds a BA from Drury College and her JD from the University of Oregon School of Law. Her writing on the Sackett decision includes a recent essay in Washington Monthly. So thank you for joining us, Adell. I'm also joined by Dr. Adam Ward. He is a professor and department head at Oregon State University's Department of Biological and Ecological Engineering. He has written extensively and received numerous awards for his research, which is focused on environmental science, hydrology, watershed management, civil engineering, and water quality. Prior to joining OSU, Dr. Ward taught at the O'Neill School of Public and Environmental Affairs at Indiana University and had a Fulbright Fellowship in Birmingham, England, studying the management of societal and natural functions of river systems. He holds a BS and an MS in civil engineering from Michigan Technological University and a PhD from Penn State University. He also has published on the Sackett decision in Scientific American. So thank you for being here, Adam. So Professor Amos and Dr. Ward recently co-authored a piece about Sackett in EOS, a publication of the American Geophysical Union. So I know that not only have they thought about it separately, but they've thought about it together. So we're really lucky to have them here joining us. I know we have a shorter amount of time than we did for the last panel. We'll try to save a couple minutes for questions, but let's go ahead and jump right into it. So Adell, can you remind us about the facts of Sackett and what exactly the Supreme Court did?
Yes. And the facts of Sackett, I see some of my former students in the room. I've been teaching this case for a long time. The Sackett litigation has gone on for about 15 years or more. So for those of you that don't know, this involves Michael and Chantal Sackett, who began to fill with gravel a lot that they purchased near Priest Lake in Idaho. When in the process of the backfilling, the EPA informed them that because their property was identified as a jurisdictional wetland under the Clean Water Act, that they had to get a Clean Water Act permit. And then the EPA demanded that they refused to get the permit. The EPA demanded that they restore the site or face penalties. Those penalties were up to $40,000 a day. And EPA had identified the wetlands on the Sackett's property as water covered by the Clean Water Act based on what at the time was called the significant nexus test. So for my former water law students, we've spent some time on the significant nexus test. And it was a pretty straightforward inclusion of the property under the significant nexus test and the way that had been implemented. Of course, the significant nexus test was the result of a lot of litigation under the Clean Water Act about the scope of that act, Congress's ability to regulate clean water, which is really what the case ended up being about. So there was a lot of disagreement. I do want to mention that, for those of you that were here in the last panel, this case was very particularly designed to challenge Congress's authority under the Clean Water Act. So sometimes this case gets described in really sympathetic terms vis-a-vis the landholders, and I can understand, as a landholder, that sympathetic, but everyone should be very clear that the plaintiffs were chosen. It was set up to bring a very particular challenge, to press against its impact litigation, to press against the scope of the Clean Water Act. So very quickly, the plaintiffs were unsuccessful. The EPA's decision that this was a jurisdictional wetland was upheld by the federal district court in Idaho, and on appeal to the Ninth Circuit. When it went up to the Supreme Court disagreed with the EPA's classification of the property as a wetland. The court was actually unanimous in reversing the lower court's decision, but would have done so on differing grounds. The majority opinion created a new test for how we identify jurisdictional wetlands under the Clean Water Act, which very significantly constrains the scope and reach of the Clean Water Act. So I'll leave that there.
Sure. Terrific. So, Adam, maybe you can tell us, what this means on the ground from a hydrologist's point of view.
All right. So, at a high level, I take this decision as a signal that our streams and wetlands in the U.S. are at their most vulnerable in more than 50 years. So that's dating back to the passage of the Clean Water Act itself in 1972. In half of the states in the U.S., there is no state level nor local protection. So half of our states and territories, it is the Clean Water Act and the federal rules that stand between the filling of wetlands to build on, the using of wetlands for the disposal of trash. And when we do these things, we remove their habitat benefits, we remove their flood control benefits, we remove their processing of pollutants that they naturally do for us on the landscape. And so that leaves all of us vulnerable as downstream landowners, as people who like to fish or recreate in rivers, lakes, streams here in the States. So just a couple of key concepts here as the sort of token scientist on the panel today. The way that wetlands and headwater streams are protected in the U.S. Derives via the Commerce Clause, and our general agreement that we would like rivers, lakes, estuaries to be places where we can move goods by barge and where we can recreate. All of the court cases that we have seen make it to the Supreme Court are essentially questioning how far upstream affects the quality of those places we agree upon. So we broadly agree we ought to be able to barge the Mississippi River. How far upstream must you protect in the channel network or onto the landscape in order to retain those benefits in traditionally navigable waters? That question has been at the core of several Supreme Court cases over the past 50 years. I just talked a lot about streams, but this is a wetlands case. Wetlands derive their federal protections because of the impact they have on the health of streams. So the physical, chemical, and biological health of our streams and rivers is intimately tied to the wetlands that are connected to them. Water may flow out of a stream into a wetland temporarily, provide spawning habitat for a fish. That wetland may retain some sediment load that would have otherwise inhibited navigation downstream. So that intimate connection means that protecting our surface waters requires protecting our wetlands. That's been very clear since the Act was passed in 1972, made even more explicit when it was first amended to include adjacent wetlands. Nonetheless, we've continued to argue about it for many years. The decision to protect a wetland really requires a two-part test, perhaps, from the scientific side. Why would I say a wetland is protected? One, we would need to agree that the surface water adjacent to it was protected. And we have fought over the years, we've argued whether a stream that could not be barged but could be navigated in a canoe or have a log floated down it counted as a surface water that we would all agree is protected. What about a stream that flows part of the year but not all of the year? Arroyos in the desert Southwest, where their flood conveyance is incredibly important to our way of life a few days a year. And if we destroy them, we get widespread flooding. So they flow very seldom, and yet it's very important to the health of the system and to the well-being of the landholders. So if we could agree that a waterway, like a stream, is protected, then the second question becomes, how connected must a wetland be to justify its protection? A wetland that is immediately adjacent to the Mississippi River, one kind of case, or where a lake slopes into shallow vegetation that becomes gently terrestrial. What about a wetland that has a berm between the river or the lake and the wetland? What about an isolated wetland that's used by migratory birds? So these are some of the discussions that we've had over the years. What changed in Sackett? We, since 1986, we have been clear that a river not need flow perennially in order to be protected. That was in rules from the Army Corps and the EPA as long ago as 1986. The Sackett decision calls into question how often something must flow in order for it to count as a channelized water body like a stream. We removed the idea that wetlands may be connected to streams by something other than flow across the land surface. So we as a scientific community have well understood that water flows below our feet between wetlands and surface waters, even if there's a dry patch in the middle. That concept was removed in the Sackett decision. And finally, in the Rapanos case, the courts were very clear that we need to consider similarly situated wetlands. And the idea here was to avoid a death by 1,000 paper cuts scenario. So while your one tiny wetland on your property may not matter, if we let you fill yours, we must let everyone fill theirs, and you do have a substantial loss. The last bit I wanted to add, and then I will pass it back here, that's some of the key changes. How many wetlands are we actually talking about here, losing federal protections? The short of it is we don't know. The agencies have, depending on who we ask, either declined or been instructed not to produce estimates of what the geographic scope is, of how many wetlands we're talking about. Now, this is despite new rulemaking efforts during the Obama, Trump, and Biden administrations. So we've done it 3 times in the last decade. While the agencies have declined, some of the academic and private sector have attempted. A few studies from our group suggest that in the Wabash River Basin, for example, where I used to live, more than 80% of wetlands are more than 100 feet away from rivers. So approximately 80% of wetlands are definitively out based on Sackett's ruling. Of the 17% that remain in, my estimate is perhaps 10% of those would meet the continuous surface connection requirement. So we're talking about federal protections in that basin having been stripped for more than 90% of the remaining wetlands. In the state of New York, it's more than half of wetlands that are within 100 feet of the stream, and I'm actively working with colleagues to now assess how what we define as a stream starts to impact what remains. But again, in that case, we're thinking no more than 20% of wetlands that were protected pre-Sackett would still retain their federal protections. So this isn't an edge case of a few wetlands here or there. This is a dramatic shift in the extent of federal protections for our wetlands and waterways.
Great, thank you for that, I think. At this conference last year, Professor Heinzerling and I discussed the case of West Virginia versus EPA. And Professor Heinzerling described that case as really a power grab by the judicial branch vis-a-vis over Congress under cover of separation of powers. And some have seen Sackett in a similar way. So Adell, I wanted to ask you, what's your view about separation of powers and what Sackett and perhaps West Virginia versus EPA has done with regard to the balance of power between the courts and Congress and the executive branch?
For those of you that were in the panel earlier, there was a comment about sort of this post-Dobbs approach that the court is taking with regard to precedent and with regard to lawmaking and policy setting from the 9 justices on the court. And certainly Sackett is very much in that vein. So Sackett fits the model of what we're seeing from this court in terms of its view of its role in terms of lawmaking and policy making in the United States. So for example, they described the affirmative action case as sort of not grappling with decades of precedent in the context of the case. That is absolutely the case here. And I'd like to note that the precedent in the clean water, while the area has been muddled, as my water law students know, and it's difficult to teach, it has also been, there have been some baseline principles about what wetlands should be protected that have carried through since the Nixon administration, Republican and Democrat, baseline principles, including in the Trump administration, including when I served in Bush 1 as a staff attorney, that have now been thrown out. And so, you know, I don't want to be hyperbolic, but I also I don't want folks to be lulled into any sort of sense that this isn't a very significant departure from what we have known in terms of the protection of water in the United States. And if you read the majority opinion authored by Justice Alito, it is very clear, like the affirmative action case, that the court is making a statement about whether or not the goals of the Clean Water Act are compelling or not for the nation. And so from a separation of powers perspective, I teach, at least, that is the job of the elected branches, right? That the compelling nature of a statute, the desire for the United States to have a law called the Clean Water Act to do that work in the world is a call that Congress makes and the executive branch implements. So, so it's very much, you know, in terms of its relationship to Congress, and many commenters now post-decision have made this observation that you know, it's inconsistent with the statutory language and it upends decades of precedent without grappling with it. It just creates a new reality. It announces a new test, and we're set to live with it, including, and I'll talk about this a little bit in response to a later question, Justice Kavanaugh. So Justice Kavanaugh writes separately in Sackett to disagree with the approach, the dramatic nature of the approach in the majority opinion. And then with regard to the executive branch, and we're seeing this in a case that's pending before the court this term, there is not deference or consideration to the agency's scientific and technical expertise. The opinion does not, as you and I have discussed a lot, I mean, it does not grapple with the underlying scientific questions. What I would argue are the facts that are at play in this case, really at all. It makes a political judgment. So that the notion that these decisions are sort of rooted in science, I think that's what motivated our joint article in the American Geophysical Union Journal, is just the really absolute disregard for that scientific expertise in the test. So it leaves the political calls that we make as a nation in the hands of an unelected judiciary, 9 people on the court. I mean, that's where it sits, which may be fine if you agree with the 9, right? You know, you may think we finally did it, right? We get what we want with these 9. But historically, we have had, I believe, more principled positions about the role of the court and the 3 branches of government at the federal level and how they relate and how the checks and balances work. And I think Sackett calls that balance into question. And I would agree with Professor Heinzerling that it feels like a power grab.
So that's like a perfect lead-in for my question to Adam. You know, we have had a very muddled history in the Supreme Court on the scope of the Clean Water Act. And in the 2006 case, Rapanos versus the United States, which is the last time the court took a bite at this question, you know, they came up with a test that has been referenced, Kennedy's test, in which a wetland would be subject to the Clean Water Act if it is significantly affected, if the wetland significantly affects the chemical, physical, and biological integrity of other covered waters, which is really a scientific question. And so now 17 years later, we have a group of scientists who presumably have for very practical reasons wanted to answer that scientific question. And now 17 years later, we learn that the importance, that the science is really the scientific question is really irrelevant to the legal question of coverage. So what effect is this going to have on the scientific community? How are hydrologists going to decide how they relate to the law? Does this change what they do, if at all?
Yeah, I appreciate that question. It has been, well, this is a much litigated issue. One thing that has been hopeful for me through the past, up until this decision, is that there was always room for science to be heard. And I appreciate that scientific judgments are different than making effective and efficient policy, and that's different than judicial decision making. But it was heartening for our community to be at the table. So in the early 2000s, a big segment of the scientific community pulled together and wrote a report that's colloquially called the Connectivity Report that the EPA approved. It's published with their full endorsement. They've co-authored it. It really codifies the preceding 30 years of science. And it was, in many ways, seminal for our group. It was sort of our arrival. Hey, the esoteric things that society has funded us to study for many years became practical. And we, as a community, I think we're very excited to contribute. This most recent turn of events is sort of a feeling that, so no one cares anymore. It feels now like our opinions or our efforts are not being considered in the making of decisions, and that we've really regressed to a point that much of the progress we've made in the last several decades is no longer relevant for the way we think about our waterways. Is this unnoticed? Are we disheartened? No. I'm here, I'm smiling, I'm working hard on this. A few ongoing activities. The National Association of Wetland Managers is working on a national inventory to try and assess on a state-by-state basis what is the impact of Sackett, considering both the national policies and rule changes and also the state-level heterogeneity that exists in some of our states. Similarly, I'm on a task force with colleagues from the EPA and the USGS that's focused on headwater streams. Again, answering the stream question being requisite for subsequently answering the wetland question. So there is movement afoot amongst agency scientists to continue bringing our science to bear on the problem, but it does increasingly feel like an uphill battle. The other item that I wanted to note, just from my side, I have a real fear from the West Virginia decision, the Sackett decision, and what we might anticipate as a pattern we're going to see emerge. I have a real concern about a brain drain of scientists from the federal agencies. My colleagues who are agency scientists aren't there to push a conservative or liberal agenda. They love their science. They are as passionate of nerds about this thing as you can imagine. They live and breathe this because it's intriguing to them and they care. And they believe that they are helping guide responsible implementation of policy, of rulemaking in managing our resources. For folks who are now sort of at the senior scientist level, they've been working on this for 20 years since Rapanos was being decided and debated. Those folks are feeling that 20 years later, after all of that work, they've just been left out of the room. Their seat at the table has been removed. And I have a real concern that not only are those folks going to maybe lose some engagement, but it's awfully hard to recruit new agency scientists coming out of their graduate programs and starting on this career path when they're seeing across several facets of environmental management and regulation, we're glad you did the science, we're making rules without you. That's one of the impacts that I fear may be coming in if we don't, as a community of scientists, find productive ways to be at the table and be a partner in forward-looking rulemaking.
Thank you. So one of the strengths of the American legal system is stability. It's very, very hard to get an environmental proposal enacted into law, but then once it's enacted, it's very hard to repeal it. And so, that stability has obvious benefits. It helps the public know what to expect. It helps businesses know that investments aren't going to be stranded in complying with them. They're not going to be whipsawed by changing requirements. The two of you wrote in your recent joint article The majority opinion invented out of whole cloth a new and narrow test to determine which wetlands are protected, ignoring scientific consensus and even the explicit intent of Congress when it wrote the law. It's a very strong condemnation, but you're not alone. Professor Richard Lazarus has written, "Nothing in the relevant statutory language compelled such an unprovoked hit job on the nation's ability to protect its waters from harmful pollution." So, I wanted to ask you, and this, with the overturning of Roe v. Wade, the debut of the major questions doctrine, now Sackett versus EPA, is the Supreme Court introducing a new instability into our legal system? Or is this, we've always had consequential Supreme Court decisions, is this different? And if so, how should policymakers, advocates, or scientists react?
Do you want me to go first?
Sure.
I stand by the statement. And for those who know me, I'm not particularly known for my radicalness. But I'm there. I believe that this is where we sit at this moment. And I'm in really interesting company, for those who also know me over time, because Justice Kavanaugh and I agree on this point. I was not necessarily a supporter of Justice Kavanaugh when he was nominated to the bench, maybe at all. Might have signed a few letters. And so I then had to publish an article in which I stated very publicly that Justice Kavanaugh and I were like this on this question. So this isn't, it may seem radical, but we may live in these kinds of times. Certainly Justice Kavanaugh said that that this was a complete departure. The court's continuous surface connection test departs from the statutory text and from 45 years of consistent agency practice and from this court's precedents. That's Brett Kavanaugh in response to the Sackett majority. Like the affirmative action cases and other cases, there is a concurrence authored by Justice Thomas that goes even further. And would limit the reach of the Clean Water Act more. And so, for those of us who watch the court now, there is concern that that's the roadmap, that Justice Thomas's role with this new court is to, the majority goes as far as it can get, and Thomas then takes up the oar of articulating the next measure and lays out the next litigation strategy for this kind of litigation. So we're in for it on the Clean Water Act. And so I'm not backing away from my statement.
I'll stand there with you as well. So for me, and coming at this as not as a legal scholar, admittedly, right? But what concerns me is that we have this new retroactive test that says, was this a major question? With no definition of what major means, and no opportunity to ask Congress, did you intend that? Instead, we have the judiciary simply saying, we perceive that was a big decision, and post hoc, you should have articulated something 50 years ago, right? And that's not, in my view, how I anticipate environmental policy making to work. So what's an example? We spend millions of dollars every month testing the quality of our drinking water. Safe Drinking Water Act. Congress did not say, thou shalt test for the following 5 compounds, nor with what frequency, nor how it should be reported out to users. And yet each of you, every year, receive a readout of the quality of your drinking water at your home, if you're leasing, and at your place of business. Right? That is EPA rulemaking. That is the agency saying, as new compounds are discovered, as we realize the impact of PFAS on human health, we are choosing to ask for tests or to require tests to protect human health and protect the greater good. It is plausible, in my view, that one says, wow, that's expensive and that's intrusive. Congress, if they meant that, they would have said it in 1974. That was a major question. So let's strike that rule. That, for me, is the fear I have of this major questions doctrine is there's no apparent check, in my view, on where that ends. And so if we deem something major, then Congress should have articulated it. Of course, Congress can write new laws in a forward-looking way, But that would presume that Congress knows a priori how to achieve its goal. That a Congress who wrote the Endangered Species Act knew how to preserve the California condor before the science was there, right? And this is not a logical way for us to be making laws. Laws set directions. Agencies have the flexibility to implement them in ways that are efficient, effective, and that are mobile as new concerns come to light and as new science comes to light. So I'm really afraid of this major questions doctrine in the environmental space in particular, because the science is always changing. That's why you all pay your taxes and continue to fund us. You're not satisfied that we think we know it today, so stop looking for new knowledge. Oh, water's been fine. Let's not look at new contaminants. Let's just assume everything's okay. That's not what you all invest in our science for, but that science is not making it into the decision-making realm if this is how we're going to proceed.
Great, thank you so much. I'm just going to throw one more question that either of you are welcome to answer, and then we'll go to the audience for any questions they might have, which is, we've just seen this footfall. As you look out into the future, what will you be watching as sort of a result of this case?
Sure. So keeping it closely to Sackett, each time that we have seen rulemaking in response to Supreme Court decisions, or we've seen new rulemaking in the last 3 administrations on this front, we see states respond. And more often than not, the responses we see from the states are lowering their standards or removing their protections. So while we have a few examples, states like Indiana, who in 2020 reduced state-level protections to match the new minimum that was set by the federal government, we have yet to see a state enhance protections to take up the mantle. So what I'm watching for right now is the state-level responses. Will we see states valuing their wetlands and environmental protection and taking up the mantle when federal protections are questioned? Or will we see what we saw in 2020, will we see states continuing to race to the bottom of removing those protections, often in favor of development or the ability to modify the landscape rather than preserve it?
So the EPA has issued a rule. They issued it as a final rule, evoking what is called the good cause exception under the notice and rulemaking requirements of the Administrative Procedures Act. And that new rule will go into effect at the end of October, provided they withstand the sort of requirements of the evocation of the good cause exemption. Land developers and those who are concerned about the federal government's regulation of wetlands have already indicated both procedural and substantive issues associated. That there is fear that the EPA has not dropped the standard low enough, has not removed enough wetlands from the jurisdiction, even though it's very high. I'm like, we're like at 90. So I think there's going to be a procedural and a substantive challenge to the EPA's new rules. We'll see that, I think, this fall. Writ large, and the piece I did in the Washington Monthly really gets at this, water in general in U.S. law has always been treated very differently than other kinds of private property rights. And those who've taken my water law class, this is going to sound really familiar. This case really hinges, when you read the majority opinion, around the kinds of private interests that people may have. Here, a private landowner's interest. But what it really discusses not at all is the public's interest in clean water. So this dynamic between what is public and what is private, and what should be privatized and what is protected in that private property system is at play. And if people care about that, you should pay attention to this. One of the reasons that I think this public-private dynamic is so important is because what it really does is it implicates deep questions of equity and accessibility. Because private land and water rights are held by people who have wealth. And so statutes like the Clean Water Act were Congress's expression of what it meant to protect a set of public values on behalf of all of us. And so I think, that's what worries me, that that's in play. I have lots of, just 3 more, I promise, and then I'll stop. I hope that Congress acts, but we all know that that is a difficult space as well to get any kind of action. But Congress could respond to the courts and say, we mean X. States can act, as you have indicated. Tribes can act under the Clean Water Act, under the Tribes as States provision, so I'm curious to see if tribes will act. And then, as our EOS article says at the end, scientists can get in the mix. And I really want to commend Dr. Ward. I met him just last spring as this was all rolling out, and he joined the OSU faculty. I represented scientists for years as a lawyer. And we experienced this in trying to publish our article with EOS. The scientific community does a really nice job of kind of staying out of the fray. And it's hard for us, a scientist. But that should be a testament to you of where we're at, right? And I think scientists are going to have to get in the mix. We need you. So I'm very grateful that you're in the mix. For me, I worry that we're at a point in history of the nation where the overarching project is actually to break government and make us all really cynical about what government can accomplish on behalf of the people. So I hope we don't lose sight of that. Yes, the Clean Water Act implementation has been muddled and difficult, and it's not a great story, but we have a Clean Water Act, right? And so this project to break it worries me, deeply. It's why I'm glad all of you that are in law school are in law school. That's our work, is to not let it get broken, I think, so. I'll stop there.
Terrific, and I think we have a roving mic again for anyone who has a question.
So originally I was thinking Congress could step in and clarify what they feel is important and what the purpose behind the act is. But if part of the ruling is that these certain streams or wetlands aren't connected to navigable waters, really is the court cutting Congress off at the knees and saying, you have no federal role here, you have nothing to regulate because there's no federal nexus?
This is a question of the scope of the Commerce Clause authority under the U.S. Constitution. As I teach in my water law class, never has one word been asked to do so much, the word navigability. The navigability doctrines that are related to questions, sorry, this is going to get a little technical, that are related to questions under the Daniel Ball test are about determining title as between a state and the upland owner. They are not questions, and I think the court is very muddled on this, and Justice Kennedy was very muddled on this. My students know we spend a lot of time unpacking this. It is very important for Congress to articulate very clearly that what it's exercising is its Commerce Clause authority, and that does not, Congress has Commerce Clause authority in the water spaces that aren't tied to navigability. That's how we have a Safe Drinking Water Act, right? Because our drinking water doesn't necessarily always come from a navigable waterway or from an interstate water. And so disaggregating this concept of navigability from navigability for title, for determining the title to a bed of a navigable water, from the question of the scope of Congress's Commerce Clause authority, I think will be very important if Congress tries to act in the space. And then we will see what the court does with it. I mean, this court isn't super interested, I don't think, in broad Commerce Clause authority, but I hope we try. So I don't know if you have a...
Yeah, I mean, I would add a recognition that this is one Supreme Court decision that has dealt with which waters are connected to which waters. For me, I find sort of sadly humorous, perhaps. The prior decision that I was paying a lot of attention to was Maui versus Hawaii Wildlife, in which it was very explicit by the court that pollution can travel with water through the subsurface to a navigable water and be regulated. And we simultaneously have learned that water moving through the subsurface is not a basis for things being connected. So there is some inconsistency out there in the ways that we've interpreted what is connected to what. And so I'm not sure that Sackett alone slams the door as much as perhaps establishes a different paradigm that is going to, Congress could perhaps take issue with the various interpretations and then use that divergence as a reason to redefine what they mean or reassert their authority. Hopefully that was coherent and felt a little rambly halfway through.
I also find it very unnerving to be in agreement with Justice Kavanaugh, but that concurrence did a very good job of sort of laying out Congress did have this intent, and that is a ridiculous association of what water is and where it comes from. But on that subject of water, which is a very complex system, I'm not a scientist, but my understanding is that wetlands are a very important filtration system, and that a lot of our drinking water actually percolates through them. So is there any way that the Safe Water Act could impact this type of application, and that there could be protections under that, but also on that question, our global climate system is also meaning that our water sources have been deeply impacted by flow rates, and any movement there?
So I'll give sort of a quick response. On the Safe Drinking Water Act side, my sense is that we're primarily focused there on water after it has been in the environment, so after it's been withdrawn. So it would be a pretty big move to extend before the pump or upstream of the pump out into the environment from that perspective. You're spot on. Wetlands and these headwater streams play a host of critical roles in maintaining the quality of downstream waters. If we cared nothing about environmental habitat, we would still care about wetlands because they make it cheaper and more efficient for us to generate clean drinking water and protecting us from flood damage. So I'm in agreement with those points. I'm not sure how we are going to navigate this moving forward.
I'll just, since I'm sitting up here, as a young staffer in Congress, I worked on the reauthorization of the Safe Drinking Water Act in 1996, and there is a protection program for source water protection program, completely voluntary. And so the overall point, I think, is it's about monitoring water that's in the pipes of your drinking water system is what that law is about. But I think the point is that Congress has the authority, should they choose to act upon it, to fix this kind of problem. But it's just extremely difficult to get these kinds of things done in Congress. Even though you have many well-intentioned people there, there's lots of gates that prevent passage, unfortunately.
We should just note as a fun fact here, 50 plus years later, that the Clean Water Act was an override of a veto by a bipartisan Congress, which may be hard to imagine that sort of groundswell of activity addressing these kind of issues, even though Congress acting would be the most straightforward way to reassert their intent as it relates to the scope of the Clean Water Act.
And I think with that, it brings us to our time, so I hope you'll join me in thanking Adell and Adam for their being in the panel.